We now have 3 scenarios for you to have a think about. These are situations that have been suggested to us. First of all, you'll hear and view the text of a conversation taking place between tutors in a college. JISC Legal will then provide a response for each, discussing the various relevant legal issues.
Oh, you'll not believe what Sue just told me. Students have been telling her that they had found a Facebook group all about Mr. Broom. It's already got some members. Students from the college, and they have posted some really nasty stuff all about him. It says Mr. Broom is a really bad teacher. You know the usual stuff they talk about when they don't think we're listening? Well, Mr. Broom is furious. He went to IT services, but they said it wasn't their job to sort that stuff out.
Well, he does use Facebook to chat to students, but that's not on. It could happen to anyone. Isn't that sort of thing covered in the acceptable use policy?
The first thing to be decided is how serious the remarks are that have been published on the Facebook website pages. And I choose that word published on purpose because publishing a defamatory statement is the language of the law of defamation. So what does really nasty mean here? If the words are defamatory, then pursuing those who published the comments may be possible. Defamation is the publication of a statement about an individual with the intention to tarnish or reduce their public reputation. Whether in fact the nasty stuff here is defamatory or breaks any law is tricky. The context may determine whether or not it is. Certainly, if there are words which are disparaging, this is likely to be enough to ground a claim. Calling them a really bad teacher may not be enough on its own. A defamation action is a blunt instrument and is costly and difficult in terms of evidence, as the onus is on the person allegedly defamed to establish all the facts. A formal written request from the college to the students which mentions defamation and perhaps a breach of the acceptable use terms of the institution's IT facilities may have the desired effect. Facebook, I imagine, may not want to become involved in disputes between individuals, but if they receive a written complaint that they are publishing a defamatory and offensive statement, then they are likely to act to remove the content. Facebook make bullying, intimidating or harassing any user a breach of their terms, and these terms are available on their website. Users are also prohibited from posting content that is hateful or threatening. So, reporting it to Facebook is one of the first things to do if you want the content removed. In general, disciplining students for online conduct which is considered inappropriate is not any different really to disciplining them for inappropriate conduct in any other environment. So, if the conduct took place in the non-online world and could be considered a breach of discipline, then it could be considered a breach of discipline in the online world. Having a statement in your acceptable use policy which includes online behaviour that has a bearing on college activities is essential.
Hi Mark, can I ask you about something?
Sure, what's up?
Well, it's a bit delicate actually. I'm not sure if I should go to guidance about it or not.
What is it?
One of my students, Miriam, was a bit upset today in class. I asked her what was wrong and she showed me a text on her phone. It said a really horrible thing about her, about the fact that she's from India and she hasn't got any friends because of it. And it said that if she told anyone she'd get beaten up.
Oh, that is awful. You will have to report it. Where is she now?
Well, I told her I wouldn't tell anyone. It was the only way she'd tell me what had happened.
While more than one incident of the use of ICT to cause intentional upset is usually needed to be considered cyberbullying, when the incident is racist, faith-based or homophobic in nature, then it does not necessarily need to be persistent to be considered bullying, especially as with Miriam, when this is coupled with a threat of serious bodily harm. The undertaking given by the tutor not to tell anyone was ill-judged, as under the Education Act 2002, colleges have a duty to safeguard and promote the welfare of children receiving educational training in their institutions. In this context, a child means anyone under the age of 18, and tackling bullying in all forms is part of this duty. Under the Children's Act 1989, a bullying incident should be addressed as a child protection concern when there is reasonable cause to suspect that a child is suffering or is likely to suffer significant harm, meaning there is also a possible legal obligation to report this incident in line with local child protection procedures. The Education and Inspections Act 2006 give powers to such an extent as is reasonable to regulate the conduct of students when they are off-site, so the text does not have to have been sent within college hours or grounds to be investigated. It is part of your inspection requirements that all staff at the college receive child protection training, and this scenario highlights a probable training need for the tutor in question. The tutor should speak to Miriam in private and sensitively rectify the situation, explaining the legal requirements for this serious matter to be investigated properly. The focus going forward should be on supporting Miriam positively throughout this process. When investigating the incident, if the perpetrator can be identified, then appropriate action should be taken in line with college policy. The anti-bullying lead, with the consent of senior management, may decide to involve the police if it comes to light a criminal offence has been committed. Anonymous texts can be easily traced by the police, so ensure students are aware of the possible criminal consequences of cyberbullying and how the college intends to respond to this.